Hi, I'm Tom Marks with the Marks Law Firm in Orlando, Florida, and welcome to The Healthy Family Law Attorney. Today I'm going to answer the question, how long is your family law case going to take and how much is it going to cost? I know every client that comes in wants to know the answer to that question, and so I'm going to give you the short lawyer answer first, and then I'm going to go into much more detail and give you a full explanation of it so you can make a good and informed decision about your case. Okay, so let's start. First, the short answer, the lawyer answer is, it depends. Well, what does that mean? Well, it depends on whether your case is going to be concluded in an uncontested way, or whether it's going to be a battle and become contested, or finally, whether it's going to go to trial. Obviously, it gets progressively more expensive as you go forward. So let's dive in. Let's get into the details of those three different phases of your case. Okay, let's start with uncontested. So the uncontested phase is defined as from the date you walk into your lawyer's office to hire them up until the day you go to mediation. And at mediation, you're either going to, one, settle your case, two, make enough progress that you want to continue the mediation and return for a second or possibly a third mediation to get it done. Or finally, there's no deal. There's what's known as an impasse. You have no ability to settle anything. Or perhaps you have settled something in your case, but there remain issues that are unsettled, so the case now becomes contested. Okay, let me just say first, about 80% of cases settle in the uncontested phase, and they can settle before mediation. You can have a four-way settlement conference, you can send a proposed marital settlement agreement and a proposed parenting plan over to the other side, and even avoid the cost of the mediation. So those are both options, but know that about 80% of the cases will settle before or by the time of mediation. So how many cases go into contested, and what does the contested phase look like? Well, this is the first time you can actually see the judge for an evidentiary or a contested hearing. Why? Because the administrative rules in our jurisdiction require that you go to mediation before you see a judge. Judges know that the vast majority of cases will settle at mediation, and so the judge does not have to handle the case if you settle it. So about 15% more will settle during the contested phase also. So with that 80% that settle in the uncontested phase, that means the court only has to deal with about 20% of the cases. And even then, 15% more will settle in the contested phase, so that, yes, in that final phase, that trial phase, only about 5% or less will go to trial. So let's talk about the contested phase for a minute. The reason it gets more expensive than the uncontested phase is because now you have to prepare for a contested hearing. I can see my cat back there. She loves to get in the videos. So the contested phase means you have to go with your evidence ready to go. So you need to have, let's say you're going to have a temporary relief hearing. So you may be asking the court for temporary child support, temporary alimony, temporary exclusive use and possession of the marital home. There may be some discovery motions, there may be a motion to compel production of documents. So you have to have all of that prepared and ready to go. There could also be temporary time sharing issues. So we're back to, it kind of depends on what issues you have for the contested hearing and in the contested phase. If you've worked out the time sharing issues and you're only going in on financial issues like support, child support and alimony, then the hearing will be less. less expensive. But if you have all of the issues and neither party will, let's say, move out of the former marital home, then you've got the issues of temporary exclusive use and possession of the marital home also. So arguably, each additional issue that you have to put on in the temporary relief hearing can make it more expensive. So the cost of the contested phase of the case increases from the cost of the uncontested phase. All right. Now, before you go to trial, and I will say the trial phase is by far the most expensive part of the case. If it's going to involve a custody battle, I've done prior videos on the 20 factors the court must consider in reaching a conclusion in a custody case, but you may also want to have expert testimony. So you may have hired a guardian ad litem, you may have hired a social investigator or had them appointed by the court, so they will be able to testify. The trial phase is when you're going to have all of the witnesses put together, all of your evidence, all of the case law, all of the motions resolved. And so the trial phase could be as short as a half-day trial or as long as, say, a 5-day trial. Typically, as a rule of thumb, each hour of trial requires about 3 hours of preparation. So an 8-hour trial might require 24 hours of preparation to get there. And it also depends, are you going to take depositions and how many depositions? I typically want to take the deposition of the other party before the trial, and there may be depositions of other witnesses. And of course, that creates additional expense also. Okay, so let's get back to how you pay the lawyer and how much that's going to cost. I have seen retainers that lawyers charge anywhere from $2,500 to $25,000. It depends on the issues involved in the case. Now, a retainer, I should be clear, is typically non-refundable. And so you should be very careful to look at that representation agreement that your lawyer provides you to see if the retainer is going to be refundable or not. My firm does not charge retainers for that reason. I don't believe that I personally should be paid for something that I don't do. So we instead require a positive trust balance, which means that the amount provided by the client is not earned until the work is performed. And the positive trust balance is refundable at any time for any reason, any unused portion. So let's say you provide a $5,000 positive trust balance, and we either one, settle the case before that is used up, or you wanted to, you reconciled. That's fantastic. For whatever reason, any unused portion is returned to you at the end of the case. Now you have to maintain that as a positive trust balance each month. And if the case does not settle at the mediation, you know in advance that your positive trust balance is going to increase to the next level in the contested case. And it could double. It depends on what all the issues are in the case as to what that is, but that will all be included in the representation agreement, so you know from the very beginning what is the amount that's going to be charged as the positive trust balance for the uncontested phase of the case up through mediation. What is the trust balance going to be required for the contested phase, and finally, what is the trust balance going to be required for the trial phase of the case? Okay, I hope that helps. Let me just add there too, there are some other options to try to keep costs down or reduced. If you qualify, the Legal Aid Society of the Orange County Bar Association or the Seminole County Bar Association or whatever bar association for the county you're in may be able to provide a free lawyer if you qualify financially for that. A second option is for the firm to provide ad hoc services. In other words, you only use the law firm for the number of hours that you request. So you could have 1 hour conferences with the lawyer to ask the lawyer for, okay, what are the next steps, or what are the next pleadings that need to be filed, or what are the issues that I need to be looking at. In the ad hoc situation, you don't have to provide a retainer or a positive trust balance. You represent yourself, but you have the lawyer as a coach or a mentor or a helper through the process. That reduces expenses dramatically. There are a lot of things that you can do during the representation also that will help you minimize costs. Keep lengthy phone calls to a minimum with the lawyer. Reduce everything you have in the way of questions or input for the lawyer to a very nice bullet point email, so that you have a record of what you provided to the lawyer or what questions you asked. The lawyer can read the email more quickly and respond to you in writing more quickly rather than that long phone call. That can save expense also, okay? There's a lot of other ideas. If you have questions for further ideas to save costs in a court case, I remiss. I needed to say, in the uncontested phase, I have had cases settle within 20 days or less of the client walking in the door. So yep, that's the amount of time at the best case scenario. More likely, it's gonna either go to a settlement conference or a mediation, and it's gonna be 60 to 90 days for that uncontested case to settle. If the case becomes contested, then we've got to deal with the court's schedule for their docket to get a hearing. So that contested case could take anywhere from 6 months to a year. I hate to tell you that, but it's true. If the case goes to trial, the case could take, a year and a half. Some cases we can get them to trial quicker than a year, but I'd rather under promise and over perform. So that's the length of time. The expense, it really, I'm back to, it depends. It could be depending on the issues in your case. If you have a simplified case with no minor children and no support issues, it can be done for less than the $5,000. If it's you've got children and a lot of issues, and depending if it's a high conflict case, I hate to say it, I've seen cases run into the hundreds of thousands of dollars on each side. I don't typically have cases like that. I typically get the cases resolved more efficiently or effectively, but the contested case can run into the tens of thousands of dollars easily if you're going to go to trial, and if it's going to be high conflict fighting for any length of time in the contested case. So the motivation is to get it resolved in the uncontested phase, and then the case will be less expensive. All right, I hope that helps. Leave your comments below. Like and subscribe to the channel, hit that bell icon, share this with anybody you know that it may help, and I hope I have provided that hope and help. The purpose of my channel is because I believe your family matters. I want to provide hope and help to your family to successfully navigate the family law process in a healthy way. So with that, I'll say goodbye and see you next week. Bye-bye.